And then what I'm going to do is we're going to go ahead and start. I'm going to set up the phone so that it's focused on Geoff Bichler, who's here with us. He's going to give us an update on where things kind of stand out there right now as it relates to COVID cases and the law and what's on the horizon. And then there's a group of us here assembled that will ask some questions once Geoff is finished. So I'm going to go ahead and switch this around now and see if that works. Hold on. Let me see.
I can't see from here. It looks like you got it.
Yep. If everybody's on mute, you can hear Geoff. Okay.
All right.
We're going to go ahead and get going.
All right. Well, thanks for having me over, Mike. I mean, I talked to Al earlier in the week, or maybe it was even late last week, and we were discussing some of the problems that we're having all over the state now related to COVID claims, and in particular the death cases that we're starting to see. There's a significant number of recent death cases. Probably all of you are aware of this. I know for a fact we had 2 Florida Highway Patrol officers that passed on Saturday. I know we had a Flagler corrections deputy, I guess, that passed on Friday. So sorry about that. We had prior to that, I think a Palm Bay officer, a couple of Orange County guys, and just really kind of in rapid succession, a lot of death cases. And a lot of questions then surrounding, well, what do we do with these cases if they're not being recognized as line of duty? And line of duty, of course, means workers' comp. Workers' comp. In a very death case, the death benefit would find payment, funeral expenses of $75. And then in some instances, there's an additional statutory entitlement under Chapter 112. So, again, depending on circumstances surrounding the death, it could be anywhere from an additional
40 to 11 day international there.
All those $125,000 additional. And then in rare cases, you also got the public safety officer benefit, which is a federal benefit that can pay a quite substantial sum. But those aren't typically implicated in COVID cases, all right? And there are a lot of reasons for that I won't go into. But the bottom line on this is we've got a lot of families out there who are grieving the loss of a law enforcement officer or a firefighter, and they are not aware that they have an entitlement, and the agencies are not putting that information in their hands, so they can't even process claims. As a matter of fact, we have been told secondhand that Brevard County is not even allowing people to file injury reports or file these claims as being work-related conditions. Now, I have not confirmed that independently. I'm just being told anecdotally. Is that true?
That's true.
That's true. Okay. So, that number one is illegal if that is true. They can't tell you you cannot file a first report of injury. And certainly in a case of COVID death, it's the most obvious thing that needs to happen. But somebody's got to put the agency on notice. And what we're finding is these families are not aware there's any entitlement. The agencies are not sharing this information, right? So the family just goes on about their business, preparing for a funeral and maybe collecting a health insurance or a life insurance benefit of some kind, but not collecting this other statutory benefit that may be applicable. So this is really a big problem. And, I think it's important now for the fraternal organizations, the PBA, the FOP, the firefighters, to really circle their arms around these families and say, look, you may have this entitlement, talk to a lawyer and get this thing squared away, at least file the claim. It's not to say they're going to pay the claim necessarily or not fight it, but you've got to at least begin the process in order to hope to have any success at all. So that was really the first and probably the most important thing I wanted to talk to you about, Mike. I've spoken to Al. I thought it was really important your membership be aware of this. But just generally talking about COVID, it's clear we've got a continuing epidemic with respect to the variant. And, even people now who have been vaccinated are having breakthrough infections. These are not insignificant numbers, by the way. notwithstanding what you may be hearing in the media, a lot of people who've been vaccinated are getting sick. Matter of fact, I heard Bill Belichick this morning. He was talking about the Patriots, and Cam Newton wasn't vaccinated, so they're going to let him go. Well, Belichick says, that really wasn't relevant to the decision, because we've got a lot of guys who have been vaccinated who are still getting sick. And that's true by and large in the larger population. So, the thing that I've been saying since the beginning of this is, these are difficult cases to prove legally, because it's very hard to isolate where you contracted the COVID virus. All right. And so the unfortunate reality is the law requires us to basically demonstrate causation directly with a specific exposure. Those are, that's a very hard legal burden to meet. So from the beginning of this, I've been suggesting the best approach would be presumptive legislation. And we've had a few media interviews related to this. I know, Mike, I think you had a media interview also yesterday or the day before. And so they're starting to catch on to this, and they're beginning to push a little bit for a legislative fix, which would be presumption similar to our heart bill. If something was filed yesterday, a matter of fact, they just copied this, they just printed this off before I left, amending chapter 112.181. All right. And this is our infectious disease statute. So they're amending this basically to cover COVID. They are requiring vaccination, I believe. But it is creating at least and trying to address the issue of causation for COVID cases. So if you are a first responder and you now contract COVID, if this law goes into effect, then it will be presumed that that condition was contracted on the job. That makes sense to everybody?
And that's, you're saying that says though only in the cases where you've been vaccinated.
Correct.
Okay.
So they're sort of laying down the gauntlet on vaccination. But what it does is it eases the burden then that I have of trying to prove a case for a law enforcement officer. All right, because I have the benefit of the presumption. Doesn't mean the employer can't still defend the case and say, well, yeah, you have a presumption, but we think you got this from your wife who's sick and came home, and that's where you contracted it. All right. But we do, if we have that benefit of the presumption, right, at least it puts us on good footing to begin the case. And there may still be some other defenses that they can raise, they can rebut the presumption, but at least it gets us, a foot in the door. So that is very important. And this will certainly be amended. But again, assuming the best, it won't pass until the next session, which is starting in January. And then the governor has to sign it. And then it won't, in all likelihood, go into effect until probably July of 2022. All right. So ask yourself, well, what good does that do? If it's July of 2022, the reason it still matters is this affects the burden of proof. And as a law that affects the burden of proof, it is retroactive, or at least there's case law on that point. So the legislature can retroactively address this issue and give us coverage for COVID all the way back to the beginning of the pandemic, essentially. That's how I'm reading this, and there's good case law supporting, that theory. But again, the better approach and I've said this all along, is for agencies simply to recognize responsibility and pay benefits where it's obvious or there is some reason to suspect the person contracted COVID on the job. All right, so that has been my sort of public policy pitch on this, and our approach as a firm from the beginning, which is we're taking any call from anybody who has COVID and thinks they got it on the job. And then on a case-by-case basis, we're making an assessment of whether we can win cases based on facts. And we've pursued a large number. I think we probably had close to 300 COVID cases in the course of the last 18 months. The majority of those, we've done pretty well. But some of them are denied. Some you have to litigate, obviously. Certainly with regard to the death cases, though, this is where I really feel the focus of the organization, the PBA as an organization, and your membership. That is a place to really focus your energy and attention. Two reasons. If you can highlight the deaths that they're not paying benefits, what does that do for this? Right? You create enormous leverage to get this legislation passed, because you have to think from the perspective of a politician. You've got widows; they want to help the widows, right? And so, what can they do? They can pass this legislation. And then, what we'll do with the death cases, as we are seeing the families come forward, we'll go ahead and pursue these benefits. We'll let the agencies deny if they're going to deny, and then we will litigate those claims to the extent that we need to do it. The media will get a hold of that, and they're already aware of this. Mike, you and I both did interviews with the ABC affiliate in Orlando yesterday. I heard from the CBS affiliate today and the Fox affiliate today, because they both are now sort of catching wind of this problem. But it's an ongoing sort of moving target. It's a very difficult issue. Legally, these are not easy cases, but what we'll continue to do is field the calls from anybody that's got a case that has questions, and then we'll go from there. So I think that about covers the landscape on COVID from my perspective. I know there were a specific question related to Flagler. Is that right?
Without addressing any county in particular.
Okay.
If we have a line of duty death.
Oh,
I mean,
yeah.
we have an employee who died of COVID.
All right.
And this will probably help if you give an explanation for how insurance works in general.
Yeah.
If the sheriff says, if he's out there calling it line of duty death,
Right.
is the insurance company bound by his statements?
Yeah.
And can city managers or police chiefs actually make the decision to decide whether or not something will be covered as workers' comp?
It's a great question. And, of course, elected officials always want to look as good as they can. So coming out saying something's a line of duty death, I mean, and look, I know I saw the interview with Sheriff Staley where he said this was a line of duty death. Right. So that is an acknowledgement that this condition was contracted on the job. Sheriff Staley's a great guy. I mean, he worked with us on the sick command center case. And he wanted all of his deputies taken care of, and he said that was a sick building, and we need to take care of these folks, right? But he doesn't make the final claims handling decision. So that is an important distinction. Now it does get into, you're really splitting hairs legally. It's an admission against interest, for the sheriff to say this is a line of duty death, and then for the insurance company to deny the claim and not pay the claim. But, that's something that comes out in the wash through the litigation process. But the words of the sheriff or any other person who's in charge of an agency saying this is line of duty doesn't necessarily have any impact on the underlying litigation. It can be used to your advantage, but it's not dispositive of the outcome, if that makes sense.
Right. So essentially, if the police chief says this is a line of duty death, the insurance company may disagree.
Insurance company can say, oh, no, it's not. Or the risk management team can say, well, I appreciate that you think it's line of duty, and we're really sorry this person passed away, but we got to be good stewards of taxpayer dollars, and we can win this case, and we're not going to pay this benefit, right? So that's kind of what you get into when you really get into the weeds on these cases. All right. And I know there's also a Daytona officer. I read about this recently. I think there was something on Facebook that's been hospitalized. So, okay. Oh, I'm so sorry. I didn't know. So he passed away. Okay. Well, then that's another instance of what we would consider a line of duty death, right? And something that should be pursued through appropriate course with the family being taken care of to do what we can do.
I think it's, from what I'm understanding of what you're saying, it's probably in our best interest to push hard for the agencies to accept the first report of injury
Yes.
from the individual employee when he first contracts
Yes.
COVID,
Yes.
which I don't know that the command staff is saying no. But what happens is the first line supervisors are saying, oh, no, we have no way of telling how you got COVID, so we're not going to take that report.
Right. Well, that's not how it works. You know, I mean, I understand, right? Confusing to everybody. I mean, it's strange, and I'm doing this work 30 years. I've been thinking about the problem of a pandemic for almost all of that 30 years. You know, early in my career, we dealt with bloodborne pathogens and hepatitis C and all of that stuff. And I always thought to myself, well, what happens in the event of a pandemic? And then, sure enough, here we go with COVID. And I get it. You know, it is confusing for people on the ground in agencies that this is not a traditional work injury. You know, it's not a guy blowing a back out or a knee injury, or, you know, even heart claims are confusing to some agencies. They don't understand how this works. So to suggest that, you know, a disease like COVID is work related, you can understand, I guess, intellectually how they would suggest, well, if you can't say this was contracted on the job, then you can't fill this out. But that's really not what the law provides. If you have a good faith belief, right, that you got it on the job, then you have every right to file a first report of injury. And that's what should be done in order to protect your interests. Because if you don't do this, guess what they're going to say? You didn't file timely notice. And that's one of their first lines of defense. So you wait 30 days and they say, well, you got 30 days to file this and you didn't do it. So now we're off the hook.
Geoff, can I interrupt you?
Yeah.
I know that you did this once before, but for everybody who might get this, can you actually go step by step on what should be done from the first time that you actually contract, or think that you contracted or you've had exposure? Because you don't necessarily have to contract it, other than, you know, we're working CPR, our code. Sometimes police are there working them before we do. We find out after the fact that they're COVID positive. So just to lay it out for everybody is,
What's the framework?
what are the steps that should be taken starting with the initial employee?
All right, so you should always file an exposure report when you've had a confirmed exposure. Now, a suspected exposure is a little bit more problematic, but I'm even suggesting that you should file an exposure report if you have a good faith belief you were exposed to somebody with COVID, right? The exposure report is different than the accident report. The accident report is what is filed. The injury report is what is filed when you have a confirmed diagnosis. So they're two separate documents, basically, right? Now, the accident report, when the disease is confirmed, triggers the whole process of workers' comp. That's where they say, okay, we're looking into this. Or no, we're not, we're denying it, right? So they're going to go one of two ways there. They're going to either just knee-jerk deny it and say, you can't prove it, we're not paying. Or they're going to say, we're looking into it, we'll give you a doctor, right? And then they can still deny it later. But, you know, the key from our perspective legally is that it is the first reported injury that triggers the process and gets the ball rolling administratively. I don't care if they deny the claim. That doesn't matter. I want the thing filed so that we at least have perfected our ability to litigate the claim if we need to. So on these death cases, 100%, you know, the injury report should have been filed at the point, right? The condition is disabling. He's in the hospital, like for this recent case, the Daytona officer that unfortunately just passed away. But there would also be another claim that can be filed at the point of death, because death is also recognized, right, under the Florida law as another opportunity to file an injury report. So it could be either or both. All right, but does that answer the question, Corey?
Yeah, I just wanted so that we can show when this goes out and an individual can see this and say, all right, I need to do this.
I was on a call. I was exposed to somebody. Here's my exposure report. Oh, yeah. 3 days later, I'm diagnosed. Okay, here's my injury report.
Because it's similar with us. You get some in the command staff that say, "Oh no, that's not an exposure," whereas we know that it is an exposure, and they're trying to protect the city,
Right.
Instead of the actual employee.
Well, you've got to kind of, like I said, you've got to aggressively assert your ability to do that, and you may have to do it through the union.
Yeah.
You know, I mean, if your individual members are not being allowed to do this, you can file a grievance, and get busy on that front, and also call us, and we will do it for you. Right? We'll do it for your members. If they call us and say, "Hey, the agency won't accept my injury report," guess what? Here's my notice of appearance. Here's my petition for benefits, and we're off to the races. Because really, legally, they can't do that. They can't refuse to accept it. Okay.
Geoff, can you talk about, because we get this question a lot here, maybe without getting too deep into the legalese, but the presumption and how you interact with officers who might think they possibly got COVID either in a squad meeting or tending to a victim or a suspect, but maybe it's not so ironclad to prove it. Like what does that do? How does that work? Or let me give you an example. Let's say I don't have a spouse, I don't have kids. I work these 12-hour shifts. I haven't been out much lately. I go to work and I go home, and now I've got COVID. Does that make it more likely that you can prove it overcomes any kind of presumption and that it was job related? Or just maybe talk in general about how that all works out?
Yeah. So, well, first of all, we don't have the benefit of the presumption right now. So we have to assume this is going to pass, and then that if it has retroactive effect, then how would it be applied? But that's a great question. The most of the case law we have on how the presumption works is in the heart bill context. So the ability to rebut the presumption, which is what the employer has, is dependent on facts. All right. Actual medical facts. This person was exposed off the job at home to this other person, and a doctor saying that that's the most likely mode of transmission. All right. And that's the reason the presumption is so critical, because what it does is it puts the employer in a defensive posture from the beginning of the case. It's their burden of proof, right? It's not the burden of the officer or the firefighter to prove causation. You understand that? Right. So instead of, I got to prove I got this on the job, it's they got to prove I didn't get it on the job. And I have to tell you, it will be just as impossible for them to prove a mode of transmission off the job as it is for us now to prove that this is how I got the disease.
Right. I think that's what I was kind of getting at, that with absent a presumption change.
Presumption.
Like, how do we do it now? So let's say I am married with kids and none of them test positive. Right. Does that strengthen your ability to fight for these guys?
It certainly strengthens the case. And, when we're looking at cases now, and as we have been for especially the last 8 months, because I think historically it's important to kind of spin out, Mike, the fact that when this started, right back in the spring of last year, we had the governor step up and we had Jimmy Petronas, the CFO, step up. If you saw the executive order that Jimmy Petronas issued, he was very clear that he thought, first responders that got COVID should be covered by workers' comp. Now, look, that's an executive order from the CFO. It doesn't have any real binding effect on anybody, but everybody operated as though it did. So most of the agencies in the state, they said, okay, it's COVID, it's a first responder, we'll pay it as a workers' comp. And so that's what we saw largely, right? But then that executive order expired in January. And that was just as we were starting to see the variant take off, right? So it hasn't been addressed legislatively. It hasn't been addressed through executive order. And so we are literally in no man's land right now. So yeah, how do we prove a case like that? Well, we get the facts from the client. Okay, what do you do for your job? What are you doing otherwise? You know, you go into the bowling league 3 times a week, or you go into the football games and drinking at the bar. Okay, now we got a problem. You know, and you're not masking, you didn't vaccinate. Oh, now we got a problem, right? So these are facts that come into the equation without the benefit of the presumption. Conversely, you know, if we got a law enforcement officer, goes to his job, he goes home, he does nothing. He's home, he works. He's home, he works. He masks when he goes out. He's vaccinated. Well, then obviously that makes it proving causation a lot easier for us. But right now, these are very, very difficult. I don't want to, you know, mislead anyone. They're very difficult cases to bring. But in the right instances, we have to, you know, we got to die on that hill, as I say. That's what I like to say in the firm. There's some cases you die on the hill, and because it's just the right thing to do. And I think some of these death cases, that's exactly what we should do. You know, we should find the families, get them with the, you know, okay, they're either going to pay these benefits or we're going to go to war. And we may lose that fight, but we're going to fight.
That was my next question too, and then I'll let some others weigh in. When you're talking about a death case, and yes, we've now had a couple of these tragically among our members right here in this association.
Yeah.
Can you, in a general sense, what happens if the person does not have any dependents? Does that factor into what can be done for them?
Yeah. So yeah, the Work Comp Act does provide, it requires dependents. So in order to qualify, now the funeral expense is a different issue. That $7,500 funeral expense, up to $7,500, is payable regardless. But the $150,000 does require some measure of dependency. We have to establish that. Now, that's not real clear as to exactly, you know, who is a dependent. You know, so we've had some recent cases, I won't get into specifics, but, you know, like a sister who may be in her 20s who lives with an officer. Is that a dependent? Well, yeah, you know, arguably it could be. So, you know, you've got to be creative sometimes, but the dependency issue is applicable not just in the work comp benefit, it can also be applicable in the context of the 112 benefits, those enhanced death benefits that we're talking about. So that is an important consideration. I think what you guys can do as leaders of your organizations is just try to identify in each of those individual cases, identify the next of kin or family member that you think would be the appropriate person to make the claim. And then, you know, we'll go to work. All right. Yeah.
If you could explain to the membership, and unfortunately, a couple of times recently, I've talked to family members who were concerned that their loved one was going to die.
Yeah.
First question is, if the husband or wife, whichever one's in law enforcement, dies with COVID, how many days do they have to, and what do they need to do? And then 2, what I've done is refer them to your firm.
Okay.
But they want to know in general, hey, you know, if this law firm's representing me, you know, what's it going to cost me? Those kind of things.
Okay. So we work, you know, this is very similar to the personal injury model. So we work on a contingency. So we only get paid if we secure benefits. But there is one important difference in these cases, because it's part of especially the workers' comp benefits, because it's part of the Work Comp Act. That's how the state legislature set the system up, as a contingency model. So we can only charge a percentage of whatever we recover. But we also get paid hourly if they deny the claim and we beat them. So in those instances, then the employer or the agency, whatever it is, has to pay the attorney fee if we beat them, say on a death case. And in that instance, then there's no fee that the client has to pay, because the employer is paying the fee. And in many instances, the employer will simply agree to pay the fee on top of whatever we recover regardless. So I know that's always a big concern, is people are, well, I don't have money to pay an attorney. You don't have to worry about that. Okay, we'll get involved in this and we'll do what we can to navigate the system and try to get the benefits paid. And if we make a recovery, we'll get our fees out of the recovery. Alternatively, if we beat the employer through litigation, then they're going to pay the attorney's fees. Does that answer that?
How much time does somebody have if their loved one does pass away to get in touch with you to get it going?
Well, technically, under the statute, you're supposed to file something, a notice or something within 30 days. All right. I think my way of looking at this is the sooner the better. I mean, I understand the families are grieving, and this is probably the last thing they're thinking about. But you know, you got a funeral to pay for, and this could be a way to pay for the funeral too. And I don't know, like for example, what Flagler County is doing for that officer. If they're doing it as a line of duty funeral. I mean, I don't know any of the details there, but you know, that can be a substantial expense for a family, a funeral. And so this is something that can alleviate some of that burden if we get on it right away, but certainly within 30 days.
Thank you.
Okay. Anything else?
I have a question that's come up. Some of the officers at Daytona is with regards to, you know, if one of us gets exposed or if one of us catches it, the city mandates, hey, you got to be off for this, you know, this time frame or whatever.
Yeah.
If it's an exposure, no, it's 10 days.
Right.
You got to be out for 10 days. If it's you actually have it, you can't come back until you get a negative test.
Right.
Well, the city's been mandating that we use our vacation time for that.
Right.
Last year, when all this started, they
Right.
were giving us extra COVID time, is what they were calling it.
Yeah.
So, I mean, do these people that are getting slammed for their vacation time have any recourse because of what they were doing last year
Yeah.
that they're not doing now?
Yeah.
When the city's telling you, you have to be off?
This is a really, really tricky and difficult issue. And it's not, this is a statewide issue. I got a Zoom call, what is it, Christmas tomorrow, is it, with Boca Raton firefighters? Yeah, they've raised exactly that issue. Right, so at the beginning of this, we're taking care of our first responders, right? You don't have to worry about burning your time, you know, we're gonna take care of you and blah, blah, blah. Well, you know, now we're seeing a completely different approach. You're burning your own time. And if you are positive, it's not a work injury claim. You've got no benefit of any presumption. You know, all of this stuff, unfortunately, if it's not addressed legislatively, it can only be covered contractually. All right. So I want to make sure that that's understood. There's no cause of action that is available to me because they're making you burn your sick time. Right?
Well, it's not even sick time. This is just our standard vacation time.
Oh, your vacation time. Right.
We actually had one just recently. She was out for 7 weeks. They forced her to go on FMLA.
Yeah. Yeah. But this is the thing, right? This is what I'm saying to you. There's no cause of action available to me to help that officer.
Right.
Because there's nothing statutorily. Now, and if there's nothing contractually that addresses this, then you're pretty much out of luck. I mean, there's no federal or state labor law that applies to this scenario because it's just never been considered. Now, you may want to think about through collective bargaining, what are you doing about this for the future? Hey, in the event of any pandemic, and you make our guys burn, you know, they gotta go in quarantine, that's on you, right? It's not on them to burn their time. It's not their fault they got exposed, right? The same thing would be true, I would suggest, through collective bargaining, that you add a provision that if you contract the disease, it's a work-related condition. You just basically lift this language, Mike, right out of the presumption, and we probably tweak it so it's a little bit better, right? But you put it in your contract, and then it's not an issue whether this thing passes or not. But you know, unfortunately, and this is what I'm going to have to tell the Boca guys too. There's very little that we can do absent either statutory language that addresses it or contractual language addressing it. So I'm aware of this problem. I'm sorry it's happening, but I can't provide any direction as far as that goes. If somebody is diagnosed, okay, then you got the ability to file a first report of injury, right? Because you're saying, I got this on the job. Here's my notice of injury. Pay me, you know, pay me while I'm out. You're making me stay out. This is on the job injury, right? But simply because you're exposed, That's not an injury. An exposure is not an injury. Follow?
Yeah, I mean, I just think that some of the officers that are dealing with it, like the one I mentioned, you know, she was out for 7 weeks, burned all that time, which is,
And she was positive?
well, yeah,
She was positive.
hospitalized,
Oh, wow.
but she was at the point where, you know, she's almost ready to retire. And at the end of her career, she's gonna cash all that time out and get a big old check, and now it's
Now she's not gonna get
now
that.
it's gone, it's all gone.
Yeah, I mean, she could file a first report of injury. She probably was not aware of that. You know?
Probably not.
But yeah, I mean, it's a leverage point, you know, and you could begin litigation in that case and see where it leads you. But again, because there are so many of these cases, we have to be very selective about what kind of cases we're engaging in. And, you know, if you got somebody like that, and so she's got 7 weeks of potential lost wages, I mean, that's $5,000-6,000 maybe in lost wage entitlement she may have. It's not insignificant, but it's really hard for us to win. So we have to gauge, okay, are we going to get engaged in that case and spend 100 hours trying to litigate over $6,000? And if we lose, we don't get anything, right? So these are the cases that become problematic. Death cases, the more catastrophic cases, they're easier for us to say, okay, you know, we got to go to work on this one. All right.
To be clear, I think it's important to, if a uniformed officer, in the case of firefighter, is the same. They say, listen, I got COVID. I believe I got it on the job. I want to file the first report of injury. And the first line supervisor or the command staff says, we're not accepting that. HR says, no, you got COVID. We have no way of determining how you got it. We're not going to do that. We file a grievance. That needs to happen in all of those cases.
I would suggest that because again, they're acting, you know, there's nothing in the law that allows them to do that. Right? You have a good faith belief that you contracted this on the job. The employer has to accept the first report of injury. I mean, it's written into Chapter 440. Matter of fact, the officer has an obligation to report it if he has a good faith belief. So they're really in violation of the law by not accepting. So yeah, I would say for sure, grieve it. And then have them call us and, you know, we'll talk about their legal rights and whether or not it's a case worth pursuing through, you know, formal litigation. But, you know, again, we're a relatively small boutique firm. And we're being flooded with these calls from all over the state because nobody's taking these cases and nobody's doing the work, unfortunately, except us. But we'll keep doing what we need to do. Yes.
Under that proposed legislation, and forgive me, I haven't had a chance to read it.
Yeah.
They're thinking about making it retroactive if they pass it. But is it a case where it would be a good idea for somebody to get their shot now? Because if they don't get vaccinated, even if they pass that law,
Yeah.
you know, and they don't get COVID, it's not going to be retroactive.
That's how I would read this, is that you should have the vaccine before you contract the disease. Now, for anybody that contracted it prior to the vaccines, I think, you know, you got no issue. But if you had the ability to take the vaccine, you didn't take it, and then you later got COVID, I think this is it'll be problematic to get coverage under this law. And again, I haven't gone into great detail in looking at this. It's hot off the presses. So this will be subject to some modification, I'm sure, through the committee process. And hopefully we can make it a better law than what it is right now.
Thank you.
Yeah, sure. Okay.
I got one more.
Yeah.
If you would. What about mandates? Everybody's aware of what's going on in Orange County right now with them mandating the vaccine.
Yeah.
Is the county going to be and Gore City is going to be responsible for any adverse effects as soon as they mandate it?
Yes. Yes.
And what about if it's incentivized? Like right now, Daytona is offering time off for those
If you get the vaccine.
if you get a vaccine, whereas a person does not want to do it, but they're being incentivized to do that. Is there any recourse that you might be able to go back just on the incentive alone, if there's an adverse reaction?
Okay, so this is
Obviously.
it's an interesting problem related to vaccines, and there is some case law already that we've been involved in fact. Adverse responses to vaccines that are required, that is a workers' comp issue. So it is considered a work-related problem. So if they're mandating it, they can't deny responsibility for any adverse outcome. All right, so that's number one. I don't think the incentive issue is a factor at all. I mean, you're either gonna, if you're mandated to get this vaccine, you're gonna have to get it and to keep your job and all that, right? And so, if you do that and you have an adverse reaction of some kind, then that whatever that is will be covered, and all your medical care, any lost wages, all of that should be considered a work-related issue. All right.
Kind of along those same lines, somebody just asked me, who's watching, if they have either a medical reason or an allergy to the vaccine or whatever, are there going to be provisions made in that legislation for those people? Like, I mean, if you can't take the vaccine,
If you can't take the
right, if
vaccine,
you have an allergy to it, or whatever, you can't take it. Those
well,
people
yeah.
have
So
to
in
be-
other words, if you have a valid medical reason for not taking the vaccine, I don't.
It says it in there, that you have to have a note from a doctor.
Does it say it in the body of the law?
For, under the immunization part of it.
All right, let me look, because I haven't seen that.
One 41.
Line 141.
The absence of
Oh, yeah.
preparation.
Absence
The
of
physician determines in writing that the vaccine, immunization, or other whatever would pose a significant risk to the worker's health.
yeah. So as I'm reading this, then if you've got basically a doctor's note as to why you can't have the vaccine,
Right.
then that should be sufficient.
Also, just maybe Geoff, reiterate for folks that you've been around the legislative battles for 30 years like we have.
Right.
Everything that's in that paper right there is likely to change numerous variations before it sees any
Yes.
actual law.
And the trick from my perspective, because I'm on the ground litigating these cases, right? So I know exactly how that language is going to be understood by the judge of compensation claims and the appellate court when they come to consider it. That's why it's really important to engage on a granular level with this language. This is the first shot at it. You're right. It's likely it's going to be amended. The goal will be to make it more beneficial, and the other side will be looking to make it less beneficial. I say the other side, I mean League of Cities, League of Counties, the big municipal employers in the state that don't want this thing to pass for whatever reason. But honestly, and I think you sent me an email to this effect, Mike, this should be a feel-good piece of legislation that everybody supports. I mean, you go back to the beginning of this and we all like, look, we got to take care of our first responders. I mean, you think Governor DeSantis doesn't want to take care of the first? Of course he wants to take care of the first responders. It's his political bread and butter. The same thing with fire service. Petronas, all those guys, they should be lining up to support this, and you're not going to have Democratic opposition to this, right? They'll what the Democrats are going to do? They go, well, what about the healthcare workers and what about the teachers? We got 4 or 5 dead teachers in Broward County that I got a call a couple days ago. Well, look, we can't help the teachers. Sorry, but given the political climate in this state, I think the first responders should be able to get something passed. But we got to get on the same page, and that's why I think it's important that we take these death cases and that we really highlight the inadequacy of the law right now through putting a bright light on those death cases that are not being paid. And we've got to get that highlighted for the legislature and for the people in positions of power that can make a difference. Okay.
Any other closing thoughts, Geoff, before we wrap up?
I can't think of anything else. If there aren't any other questions, I just appreciate the opportunity as always, Mike, come over and chat with you guys, and we'll do anything we can to help your membership. So
All right.
thanks for the opportunity.
Thank you.
Thank you.
Sure.
With that, we'll go ahead and disconnect.
Have a